Hi there. This is Samantha from the law offices of Samantha Wolfe. And the next what if question I have for you is, what if I have minor children? How do I provide for them? And I have two answers for that. The first is that you're going to address it in your last will and testament. So if you're married, for example, and your partner is the parent of the child, what the will is going to say is, if something would happen to both of you, who would you want to be the guardian of the child? If it's something where you aren't married, but there's still the surviving parent, it would be if something happens to the surviving parent, or if you are the last of you or the surviving parent to pass away, who would be the guardian of the child. The guardian is the person who physically is responsible for the child or for the children. So that means, where would they be living? Whose house are they going to be living at? Then in the will, you can also name who the custodian is. And the custodian would be who is in charge of the money. So you can actually have that be someone different than who's physically responsible for the child, meaning where's that child living. You can have the custodian be someone different, or you can have it be the same individual. But again, the custodian is who's in charge of the money, where the guardian is who is in charge of the actual physical child, the well-being of that child. So in the will, you would name both a guardian and a custodian. They could be the same people or different people. And in Pennsylvania, we do have the UTMA, that's Uniform Transfers to Minor Act, which means that you're allowed to say that you want a custodian named for that child up until age 25. In Pennsylvania, in the will, you can go all the way up to 25. You can stop at 18 if you want, and you can pick any age between 18 and 25, but the limit is 25 in the will. If you want it to be above that, then you're going to need to look at other ways to provide, meaning a trust might be a good idea if you don't want them to receive it at age 25. The guardian would be physically responsible for the child until they reach 18. So that would be one way to handle it. The second way isn't an or, it would be in addition. I recommend, Pennsylvania has a standby guardianship form. And what that says is that if you are traveling, so if you and the other parent would be out of town and the underage children are staying with someone who is different than the person you're naming permanently in your will, who'd be the guardian and the custodian, you would do a standby guardianship form. What that form would say is, during the period that you're out of town, this person has the ability to care for that child. So if somebody would need to go to the emergency room, then the person that is taking care of the child for the weekend could go and take that child to the emergency room and consent to treatment. And again, you just fill it out if you're going to be out of town or for a limited period of time, so that that individual can have the ability to do what they need to be able to care for your child. If you have further questions or concerns, we do initial consultations, and I'd be happy to talk to you about it more in depth. You can reach us at 717-655-2676.